Disorderly conduct is a crime that can be charged in Pennsylvania under 4 situations. For the police or a prosecutor to succeed in prosecuting you for disorderly conduct, they have to prove either, first, that you were engaged in fighting, second, that you made unreasonable noise, third, that you made an obscene gesture or used obscene words, or fourth, that you created a dangerous condition with no legitimate purpose. So what do each of those mean? Well, first, engaging in fighting is fairly straightforward. If you've engaged in fighting, or they say you have, that's a basis for them to bring a disorderly conduct charge. Most types of fighting end up with more serious charges. You end up with simple assault or with mutual combat or one of these other charges. So when we're talking about disorderly conduct fighting, we're talking about something that maybe was slapping, pushing, maybe even a single punch, but that wasn't very hard, no one was really hurt. That's the typical thing that we see in the disorderly conduct realm. A second is unreasonable noise. What is unreasonable and what does that even mean? Well, unreasonable noise is one of the vaguer parts of this statute. Usually there's a noise ordinance involved. If not, it might just be that the time of day or night subjectively to the officer felt like it was an unreasonable time to be loud in a neighborhood or on a public street. These are often challenged successfully on First Amendment grounds because, of course, you may have had a good reason to be making a lot of noise at a specific time. And whether noise is reasonable or unreasonable is about as much of a gray area as it sounds. The third way you can be charged with disorderly conduct is for obscene language or obscene gestures. Once again, the First Amendment is really important here. Whether something is obscene has now been held often to be First Amendment protected. The Supreme Court of the United States has said you can wear shirts that say F the draft into a courthouse, or that you can trademark something with the F word or other obscene slurs in it. So it's harder and harder for the police to prosecute these, and we've seen less of those in recent years. Fourth and finally, the most common type of disorderly conduct charge is under this final example, which is where you've created what they call a hazardous condition for no legitimate purpose. Once again, there's a lot of gray area here, and that's where a lot of these cases end up being litigated. If you've been charged with disorderly conduct, it's really important that you have a lawyer who knows how the First Amendment applies, who understands the constitutional protections you have, and will help you to present an appropriate case in your defense.